morning, everyone. I hope you're all ready for a wonderful session. We want to welcome Dan, Dabney, and Adam. The last time the four of us all spoke, it was through a screen, and I simply just cannot tell you how happy we are to have you live in person this year. So much has been happening at the Commission, and we're going to talk about all of it, but before that, we'll do some introductions. So Dan Kahl, right next to me, is Acting Director of the SEC's Division of Examinations. He's been in that position for about 8 months, and he's actually been at the Commission since 2001. Before Acting Director, Dan was Deputy Director of the Division and also Chief Counsel. But even though he has an incredibly impressive resume, the most impressive part of his resume, he knows what I'm going to say, is that before the SEC, he was at the IAA as an attorney. So we've been lucky enough to have Dan speak to us many times over the years, and we're very pleased, Dan, to have you again today. Next to Dan is Dabney O'Riordan, and next to Dabney is Adam Aderton. Dabney and Adam are co-chiefs of the Division of Enforcement's Asset Management Unit. They're also no strangers to the IAA, having spoken to our members many, many times, including at last year's conference, but of course, as you all know, that was virtual. We've been fortunate to have them speak to us together, so we get different perspectives and sort of different sets of expertise, so we're very lucky. Dabney and Adam manage a pretty large team across the country. That team focuses on advisors and all types of funds. And Dabney does so from the West Coast, Adam from the East Coast. Dabney and Adam are also members of the division's relatively new, but I suspect very, very active, Climate and ESG Task Force. So we'll hear more about that in a little bit. And Dabney and Adam, thank you both for joining us as well. Before we jump in, we have a lot to cover. I want to give you the session's continuing education word. It is laser. As in, our panelists today will be laser focused on providing unique insights. So laser. And I'll also let whoever wants to make your disclaimer, and then we'll jump right in.
Sure. The views we express today are our own and don't represent the views of the Commission or our fellow staff at the Commission. So that covers all three of us, I think.
Short and sweet. Perfect.
Yes.
Okay, so Dan, why don't we start with you? Can you tell us a little bit about the operating status of the division right now?
Yeah, so we're still, like many other places, completely remote. We have the option to come in on if situations warrant. Or the operating status is that through early June, I believe. I don't remember the exact date. I want to say the 6th. But we've been through, I'm sure like many of you, several fits and starts where there was a date and then it got pushed back. I am optimistic, very hopeful, that we'll be back in the office in early June, but TBD at this point. And I think that one of the questions that I've gotten more often is not just the operating status of the division, but when might you expect to see us back in your offices? And I don't have a concrete answer for that. I think we've been thinking a lot about it. I think without a doubt there will be an on-site presence at some point in the future, but I also think we've been very effective operating remotely, and we don't see the need to sort of be aggressive. Obviously, if there's, if circumstances warrant, we've said we'd show up in person if necessary, but other than sort of those very odd or very particular or unique circumstances, it's unlikely you'll see examiners in your offices. I said June 6th we might be back in the SEC. We'll have a sort of a wait and see approach, and more information will probably come, but I wouldn't, I think, health and safety of our staff, health and safety of all of your staff is sort of the preeminent concern, and we don't see the burning desire to show up early June, even if we're back in the office. So it'll take some time to develop, and we're considering best approaches to that, but I think that it'll be a slow and steady approach, and we'll sort of assess in real time.
And Adam or Dabney, which one of you wants to take that for the Division of Enforcement?
So we're in the same holding pattern a little bit, as Dan noted, we're all working remotely through the beginning of June. That said, the demands on the Division of Enforcement are a bit different than the Division of Examinations. So courts have started scheduling trials to go forward at this point. That's both jury trials and bench trials. So obviously our staff is participating in those trials in person, as well as we are doing some in-person activities to the extent necessary for purposes of conducting investigations. For example, when we feel like it's necessary to conduct a testimony in person, that is being done, but otherwise everything is being done remotely. Everything is still moving forward with all due speed. And so testimonies, document productions, everything that you would normally expect as part of the work of the Division of Enforcement is going forward.
Okay, so Dan, the number of investment advisors keeps growing year over year, and I think it's fair to say that your budget does not. So what can you tell us about statistics, rates of exams, where you are, what you foresee?
Thanks, Gail. Yeah, we talk about exam coverage in the IA space as one of the metrics we look to every year. Last year, we hit 16%. We sort of targeted 15% the last few years. When I say 16%, it was not we round up and round down, so we were a hair over 15 and a half, I think. So we'll take the benefit of 16. But we look at 15% as sort of our goal annually, which is from, I think, the perspective of the Division of Examinations and many at the SEC, is really not the best place we want to be at. It's kind of woefully low, I think, in many respects. We talk about broker-dealer coverage with FINRA. That's closer to 50%. But as the only game in town for most of you, SEC-registered advisors, we get to about 15% a year. But as Gail noted, the number of examiners has not really materially increased for many years. And the number of advisors continues to increase at a significant rate. In fact, I think last year, if not the highest year, is one of the highest years well, it's definitely one of the highest years in recent history. I think post-Dodd-Frank, there was a bigger bump. But net new advisors last year was I wouldn't say an all-time high, but very high. So that 15% metric is what our goal is, but it is a continual sort of race on the wheel to try to keep it. And I don't see us being able to maintain that. I guess that's probably good news to many of you. I think from our perspective, just not where we'd want to be. And I think we have sort of squeezed out as much of the efficiencies as we can. There's been some efficiency, of course, with with doing remote exams, but there are some. I mean, it's a give and take. There's pros and cons. So, I think we are going to, try to target 15%, but TBD for next year.
Okay, thank you. The IAA is a very strong supporter of the Commission's exam function, as you know, and we will try to do whatever we can in our little way.
Greatly appreciate it.
To get you some funding for that function. Let's switch gears a little bit and talk about your policy priorities. We're expecting them imminently, almost imminently. So what's your thinking on when we might see them, and what's new, and if not sort of new, changes in focus under the new chair?
Yeah, imminent, I hope, is the right adjective here. I would have, I was hoping to be able to talk for the whole hour about our priorities. I think we're pretty close. I don't control the publication deadline, so we're doing our best. Last year we got them out in March. I totally expect them to be out sometime this month as well, hopefully on the very early side. Unfortunately, not here today, so I'm not going to talk extensively about them. But if you're a student of our priorities, year to year there are sort of core priorities, and they're there year after year, perennial. And I think this year you're going to see much of the same, right? What I think you will see, probably the biggest difference, as someone who's somewhat intimately familiar with the soon-to-be published priorities, is shift in focus. And we are careful in the order in which we put things in, because a lot of us don't have long attention spans and might make it through page 3. So we try to get the biggest risk areas or biggest areas that we want to focus on early on. So I think you'll see a shift from previous years as to areas of focus, and not a huge shift in actual topics. So there's a few gems in there, but I'll keep you, those Easter eggs. I'm not going to disclose those today.
Okay. Well, I think we can take a guess, especially given the rulemakings that we've seen sort of coming out of the Commission in recent weeks.
Should not come as a surprise.
Nothing should come as a surprise. But I do think that what you're saying about the order and the focus, that probably does shift.
It matters.
It matters.
It's a message. Mm-hmm.
Okay, good. So we'll all read the first 3 pages.
Well, 2/3 of the exam program is investment advisors, so there's a lot of investment advisor parts on the first couple pages.
All right. Adam, let me ask you a similar question. You know, how have the enforcement priorities in your division and unit sort of changed under Chair Gensler?
So I think our story is a lot like Dan's story. There are key investor protection priorities that are always priorities for us. Things like, obviously misappropriation, conflicts of interest, valuation issues, fee and expense issues. And I think if you look at our cases over the last 5 or more years, you'll see that the majority fall into one of those buckets. And if you look at our cases from the last year, you'll see that we brought valuation cases, like the valuation case Valeceres that we brought a couple weeks ago. You'll see that we continue to bring conflicts cases, like the Emeritus case we brought last week and the Cambridge case we brought this week. And you'll see that we also have been bringing cases involving conflicts around cash sweeps. The last thing I'll say is we continue to bring fee and expense cases, like the global infrastructure management case from last December. But like Dan, there are areas that we can emphasize, and I think those won't be a surprise when you see sort of what all the activity is around the commission. Private funds are important. There's rulemaking there. Dan's group has put out risk alerts there. There are enforcement actions like Valeceres and global infrastructure that I mentioned, and so I think that's an area. And as Gail said at the top, there's an enforcement ESG task force that was stood up last year. That's an issue that appears to be important across the administration and of course is important at the commission. It's a similar story with a risk alert, with the creation of the task force, and with at least one matter that we might talk about later today that sort of touches on ESG issues, the Wahed matter. So I think for our priorities, very similar story to Dan, and shouldn't be a surprise that we're in pretty close alignment on what's important between exams and enforcement.
Great, thanks. So something that's a little opaque is how referrals get made and how referrals are sort of thought about at the divisions. Can you talk about whether there's been any change in how you're thinking about referrals and prioritizing referrals? And I know this is putting you on the spot a little bit, so I'm not sure what you can say. But.
No, it's a good question. I think it's really important. I was just talking a moment ago about the fact that exams and enforcement are on a similar page. And I don't think that there's been a change in how we look at referrals. We are engaged with our exams colleagues all the time. And the issues that are important in referrals are the ones that you might think are important. Is there investor harm? Is this a long duration activity? Is this something that was intentional? Is this something that the advisor has declined to remediate even after exams has brought it to their attention? We'll consider all of those things in assessing whether we want to take a referral. I also think it's important, as Dan I think would confirm, most exams don't lead to referrals. Not all referrals lead to enforcement actions, and there are some tools that enforcement has that exams doesn't have, such that things need to come over to the enforcement side for us to be able to get all the facts necessary to figure out whether an enforcement recommendation is appropriate. The last thing I'll say about exams and the referral process is that there's a feedback loop. So exams makes referrals to us, we consider them, and we go back and we say, yes, we're going to take the referral, these are the things that we thought were important, or no, we're not going to take the referral, these are the couple things that we thought about that made this not a perfect one for us. And that doesn't stop even if we take a referral, do an enforcement investigation, and either bring an action or don't bring an action. If we bring an action, obviously exams will know what we did with it, but if we don't bring an action, we do make sure to follow up with exams so that they know what we found in the investigation, because I think that learning process for both of us refines the referral process, makes it more efficient for the commission as a whole.
So, and again, maybe putting you on the spot a little bit, do you talk to the Division of Investment Management at all about referrals? Do you have a similar feedback loop with them?
We do. I mean, they're experts in the Division of Investment Management, and I think we would be a little bit foolish if we didn't call upon their expertise, particularly when a referral relates to an issue that's somewhat of a pure legal issue, whether a particular course of conduct, if we proved it, would be a violation. That's something that it makes sense for us to talk with the Division of Investment Management about early, because it's not a good use of our resources to drill into a hole that's ultimately not going to be a supportable violation, even if we prove up the facts.
I would just comment, I mean, there's so much collaboration that goes on between the divisions, and it may not be readily apparent, but, one of the complaints you often hear about government is the speed at which government moves, which is not typically fast, but part of that is the intense amount of collaboration between at least at the SEC, between IM, asset management unit, exams, in all steps, in every step of everything you probably see or touch, there's intensive collaboration. And it's very purposeful, and it's necessary, it's very helpful to all of us, but it's very important because what we say publicly, we want to be on the same page, obviously, but the message is important, and trying to be consistent about message. So it's something we take very seriously.
It would be great if you could both sort of drill down a little bit on that. Like, how do the divisions sort of think about rulemaking? How do they think about training as a new rule is coming sort of down the pike?
I can jump in,
Yeah.
in first. So, marketing is a great example. Christina was up here yesterday. I caught part of it. She has given similar presentations to us for many hours to the whole exam program. We have to train our exam staff on the new marketing rule. We have many of the same questions that you have. Sometimes we get answers, sometimes we don't. And we are as much a consumer of the FAQ process, I think, as industry is, because we don't want to lead with our chin on one of the criticisms is rulemaking by exams, rulemaking by enforcement. I think we probably have different perspectives than you have on what that means, but we're very conscientious of trying to administer the law and interpretation as intended by the commission, and we go to IM for that. So it's again, the collaboration is intense. We continue to, we'll have multiple trainings on marketing, advertising. And then on anything we get out, the risk alerts, they're reviewed. Priorities, collaborative across the division. It's just rulemaking. We wish we had more of a say, but IM has been very, very helpful. I think from my perspective, and I came from a rulemaking background, the tenor right now is there is an openness to listen to the other divisions. I think probably the most receptive I've seen in recent history, and from not being in a policy division, it's very rewarding.
And from an enforcement perspective, I think I can echo what Dan said about everybody collaborating, but I think we do a lot what you do when a new rule comes out. We read the rule, we read the release, we read the FAQs to really get an understanding of where things land, and then we talk internally. If it's going to be something that is getting referred from exams, we will talk to them at the time if it relates to a new rule. In addition, the thing that is unique about enforcement, and that sometimes gets forgotten, not by enforcement, but by others, is that any case that comes out of the commission regarding a rule or a statute or a violation goes through a memo review process that is very extensive, that includes review by the relevant and interested divisions and offices with respect to what that recommendation is. And so anything involving the Investment Advisors Act and its rules is reviewed before it even goes to the commission by the Division of Investment Management, the Division of Examinations, as well as our Office of the General Counsel. At minimum, is reviewed by all those groups. So definitely there is extensive collaboration.
That's good to know, actually. It's good to know that one hand knows what the other hand's doing and that there's a lot of coordination. One thing you said, Dabney, about you do exactly what we do when proposals come out, I do want to point out entirely selfishly that you don't have to write comment letters.
Fair enough.
Some of the rest of us do, but yeah, that is good to know. Let's switch gears a little bit and talk about risk alerts. Our conference yesterday, folks on panels really brought up risk alerts a lot and talked about how incredibly helpful they are and how grateful the folks in this room are to the division for putting them out. They generally provide a really good roadmap for compliance personnel to go back and take a fresh look at their policies and procedures. So, Dan, there have been quite a few that have come out in recent years, and again, that's a pattern that we appreciate. We know that it's hard to get them out. But what can we expect to see in 2022? Is this a trend that's going to continue, and what's in the pipeline that you can tell us about?
Well, I can't tell you a lot about specifics in the pipeline. There are definitely some additional Advisors Act-oriented risk alerts that we hope will see the light of day soon. But the collaboration and all of the work, the rulemaking, there is a sort of some choke points. So I don't know. We don't come into a year and say we're going to do risk alerts on these 10 topics or these 12 topics. It's much more organic. The regions have ideas. Some of the risk alerts are driven by regions. Some are driven by offices at headquarters. But, from our perspective, and, we do hear that people find them valuable, and I hope that's actually true. Sometimes I wonder, the feedback loop is nobody wants to tell you that your work is not that valuable. But, we'll go on faith that it is, but it serves a great purpose to us, because the exam program, our biggest impact is, or our most direct impact is a one-on-one examination. We can't talk about our specific exams by law. But what we can talk about is on an anonymous basis, bringing them all together. And we would rather be in the position where you fix a problem before we get there, because that's just better for investors, better for your clients, better for all of us. So we're going to push out as many as we can. Most of them are in the Advisors Act space, because that's, again, 2/3 of the exam program. So that's the biggest corpus of our work. So, it is difficult to get out, but we think it's incredibly valuable, and I hope you guys do as well.
So, show of hands. I mean, who thinks risk alerts are valuable?
I think, why don't you do the other way? Who doesn't? Okay. Who's willing to, because somebody must be willing.
Hands,
I can't really see any faces. The lights are bright, so feel free.
Who's courageous enough
Marianne,
to
sorry,
say?
where are you? Yeah, that's why.
What's interesting, the risk alerts, one way that they must feel helpful as well from your end, and I think from my perspective, is that I think they make that statistic that you were talking about a little bit earlier, that around 15% feel like it's maybe it's a higher number in some respects, because you're giving feedback. So you may not be going in and doing exams,
exactly.
but you're really giving thoughts and feedback. So I personally think they're great, and I think we hear that from a lot of members. So
well, we'll continue to
feel secure in that knowledge, Dan. Okay, let's turn to something a little bit more specific, and that is one of the most significant enforcement actions that we've seen in recent times, and its implications for investment advisors. So, Dabney, let me ask you, the JP Morgan case on use of personal devices, record keeping, supervision. I'm sure everybody's sort of heard of the facts, but if you could just maybe give us a quick summary and a summary of the findings, and then I'd really like to talk about the takeaways and what this means for the industry and what else you're looking at, sort of more broadly.
Sure. So the JP Morgan case, as if you read the order, or I'm assuming most of you have, is that involves a broker, obviously, who failed to, there were just widespread failures regarding the retention of certain required records by employees throughout the firm in the various business units, various levels of seniority that went on for many years. And in that settlement with the commission, JP Morgan did admit to the facts as well as to the violations, and agreed to pay a $125 million penalty, among other things. And while it involves a broker-dealer, it obviously has a lot of implications beyond the broker-dealer space, including the investment advisory space and SEC-registered investment advisors who have their own books and records requirements, including under the requirement to maintain books and records regarding possible recommendations and sort of advice provided to clients. So I think that there are very direct implications to the investment advisory space, and there are definitely certain takeaways to take from the JP Morgan case. There, what was interesting, at least to me, was that JP Morgan did have policies and procedures regarding this issue. And it included policies and procedures specifically regarding employee communications regarding WhatsApp and other types of apps for communication. And despite those policies, they really weren't implemented. Again, as I said earlier, the conduct and the use of these apps that were prohibited under the firm's policies and procedures was widespread in various business units. It included managers who were supposed to be enforcing the firm's own policies. It included employees across the board. So in my mind, one of the key takeaways is you can have great written policies and procedures, but if you're not actually taking steps to implement them on a regular basis, they're not really worth much to you. So it really is making sure to check in with those policies and procedures, make sure the training is being done, making sure there is really a tone within the firm of compliance, and making sure people are complying with what the requirements are.
So in the press release that accompanied the order, I think the commission talked about encouraging self-reports, and also talked about kind of looking at this more broadly across the industry. So what are you looking at? What are you thinking you might find? What do you think about self-reporting in this area? The last sort of self-reporting initiative was on share class selection. Is there talk about this being an initiative? Does it make sense for something like this to be an initiative?
So the press release did note and encourage firms to self-report. I will say we generally encourage firms to self-report conduct, regardless of whether or not it falls on all fours with the JP Morgan case, or if it falls outside of that. I think that there are lots of benefits to self-reporting for firms. I believe there was an email address even included for firms that wanted to self-report the particular types of conduct that was in the JP Morgan case. I can't speak to whether or not there is any sort of self-reporting initiative like that was done in the share class selection disclosure initiative. What I can encourage is that firms don't wait and hope that there is going to be some sort of self-report initiative. I don't think that that is to your benefit in any way. So I would discourage firms from just waiting and hoping that there is some sort of share class selection disclosure type initiative with respect to these issues.
So let me ask you a question about, so a lot of the folks in this room are compliance people, and it's always interesting to try to find the line between what is a compliance responsibility and what is a business line responsibility. What is compliance, what is supervision? Can you kind of talk a little bit about that in the context of this type of case and your feelings generally about that line?
Well, what the JP Morgan case emphasizes, at least in my mind, is that compliance really has to be a firm approach. It can't be a compliance office only type of requirement. If you don't have a firm that broadly is advocating for and pushing and has a tone of compliance, I'm not really sure that a compliance department alone can really make sure everything is being done. So as reflected in the order for the JP Morgan case, there were managers in various business units who were supposed to be supervising their personnel and making sure they were following policies and procedures, as well as managers who are actually violating the policies and procedures themselves. So to me, that reflects that compliance really has to be a tone within the entire firm, and it's not just a compliance office responsibility.
Dan, do you have anything from an exam standpoint that you'd like to add?
I'd say I agree with everything Dabney just said. But no, I mean, so we issued a risk alert a couple years ago, 4 years ago, on many of these very issues, and we understand the challenges, and we don't come in with an one size fits all expectation, because you all have different systems, you all have different risk profiles. We were talking earlier in the ready room how everybody in the government has 2 phones. We keep business and personal life separate. We know many people don't do that in industry, and if that's how you're going to operate, make sure you have controls around that. And this is not, the themes that Dabney just mentioned are the ones that we've talked about, I've talked about, all of you have talked about. Tone from the top, policies and procedures matter. It's not just the policies and procedures, they have to be implemented. So, I mean, those are the core takeaways. When I read the case, sort of, I wasn't involved in it. I just read the public, the release, the litigation release, or administrative proceeding. I always get confused. But I'm not a litigator, the order. And I said, this seemed like a slam dunk to me. I mean, you literally had whatever the VPs, I forget the title, sort of senior managers who were responsible for the policy violating it. And Gail, you bring up a great point, business versus compliance, and I hope in most firms, the two are interlaced enough that you can feel comfortable that when you have a policy that at least your senior managers aren't violating it, or at least at least on a widespread basis. So, the takeaways, I think Dabney, said them pretty much exactly what I would have said. This is an area that, if we come in and do an exam and find the problem, it makes me wonder, like, what were you doing? Because you're in your shop every single day. We're in there for a short period of time, and if we can identify this as an issue, I think you might want to take a step back. And I know this is one of 100 issues you're dealing with, so I get it. But well, everybody is resource drained. I think people probably use these settlements as tools, right? Look, this is what our risk is. This might happen to us. I don't have enough people to actually ascertain whether our PMs are using, WeChat or whatever encrypted device. I'm having trouble doing that.
this is your business. How do you want to deal with this? I don't know. I know and I'm sure you wouldn't say it in those stark words. I get it. Sugarcoat it a little bit, but make the principals aware of the risk. Use this as a tool. Easy for me to say, I know. So sorry.
That's what we hear about the use of risk alerts as well, that one of the reasons compliance appreciates them is that they provide exactly that kind of tool, like we're not just making this up. Okay, let's talk a little bit more specifically. Dan, you mentioned the marketing rule.
Yeah.
So we have an entire track devoted to it. Everybody's getting ready for it. There are, some new ADV questions, form ADV questions, and while the marketing rule compliance needs to begin in November of this year, the ADV questions, they're not due until the first annual update after that compliance date. So it's probably fair to say that exams are going to look at the responses to those new questions. Can you tell me a little bit about your thinking about how you look at them, how you use them?
Yeah. So, so part one of ADV is really one of our primary tools to risk assess. And when I talked about collaboration and investment management being very receptive to ideas of the exam program, you might want to look at some of the questions on ADV that were added. Questions around predecessor performance and hypothetical performance. These are exam issues that we find year in and year out. This is a perennial risk, a perennial problem. So we use that information to obviously risk assess our population. If you use hypothetical performance, are we going to show up at your door on, April 1? Probably not, because there's going to be hundreds or thousands of you checking that box. But it goes into the milieu of data points and our touch points on how we think about allocating our scarce resources and doing exams. When it comes to the marketing rule, it is going to be a challenge. As I said, I think I mentioned this earlier, is we need to train our staff. We're in the process of doing it, much like you're coming to these conferences, you're dealing with organizations like the IAA, you're trying to get guidance from investment management. We are very much in the same position and doing the same things. What it will look like and it's really going to be next year, sometime next fiscal year, because the rule doesn't come into effect, and exams usually aren't kicked off day one of a rule, and then we look back, the previous marketing rule. I don't know what it will look like. I don't know, where the FAQs will be at that point, but we will clearly be looking. One of our priorities is always looking at implementation of new rule sets. Part of that is a feedback loop to IM. Here are the issues we're finding. Here are the issues we're seeing. Here are the issues firms are telling us. We're seeing inconsistencies that can lead to guidance sometimes from IM, and that will be the process. I've said, many directors have said we don't believe the exam program is a gotcha regulator. I don't believe we are. There's a spectrum of that, and if you're using a paid testimonial and not following the rule, well, yeah, that's going to be a deficiency. But if it's a clear interpretive issue that you read the release, you read the FAQs, we're going to take that back. We're going to talk to IM. Might result in a deficiency, might not, TBD. There's so many issues that are going to arise under marketing that, as I said, I think we are sort of share the same perspectives as compliance in that regard.
Well, good. I think that's actually very comforting what you just said, because we have identified a lot of interpretive issues, a lot of issues that we feel, and that we're certainly hearing at this conference, other folks feel are would benefit from some clarity, some guidance. We don't necessarily think folks should wait for that guidance to come before they really get their implementation ready to go. But a lot of this cannot just be turn the switch on overnight. And there's a lot of repapering, there's a lot of renegotiating and training and all these things that we've been talking about. So it's really good to hear that you're not going to sort of go in on day one and really not look at it with some understanding. So Dan, we're going to hold you to that next year at this conference. I'm going to ask you about that.
If anybody wants to come and talk to me about their deficiency letter, happy to talk about it. Yeah.
Excellent. Okay, so let's switch gears to the onslaught of regulatory proposals that are coming out. And
onslaught of regulatory proposals.
I see it.
Are you leading the witness there, people? I don't know.
All right, let's call it a wave. Let's let's call it a wave of regulatory proposals. And you talked a little bit about the coordination sort of between and among your divisions on that. So I think that's really sort of helpful to know. But I'd like to focus specifically on cybersecurity. That's one of the ones that just came out recently. And it proposes a 48-hour reporting requirement for a significant cyber event. So Dabney, let me maybe start with you, and then we'll go to Dan. So you mentioned self-reporting, and there's this 48-hour reporting is in a way a kind of self-reporting. How do you handle self-reporting on cyber incidents now?
Sure. So thank you for focusing on what we do now as opposed to post-rulemaking, which I'm not going to comment
I've got
on.
Dabney really nervous, so I'm going to say, put you on the spot.
Yes. Well, I would say that we handle self-reporting pretty much the same across the board in that we engage with firms. If there is an ongoing crisis going on, and that is what they're self-reporting to us, obviously there are different divisions within the commission that help firms work through various crises that they may or may not be going through. While we may take a look at it in enforcement, I would say, again, if it is an ongoing crisis at a firm, I don't think the first thing we go to is to think enforcement. It's the first thing that we all want to do, and I think the firms as well who are self-reporting to us want to do is make sure that your clients aren't being harmed when there's a cybersecurity issue. So that really is, I think, at the forefront of everyone's mind when, again, something is ongoing and you come to us and it's a crisis. That is our concern, is to make sure that any harm is being minimized and reduced as much as possible.
So Dan, same question for you.
Yeah, I mean, there is a spectrum of cyber events, and right now we find out about them through a variety of ways. Some people come and report directly, usually to their region, because they have that relationship or they feel comfortable, or for whatever reason. We talk to our colleagues in enforcement all the time. I mean, this is another area we're very collaborative on. Exams is often in the lead, because it doesn't really make sense for enforcement to be in the lead, but we'll share information. But it really, so it's the spectrum. If we were to do an outreach on every cyber event, we would do no exams or do nothing. So, oftentimes we'll call. Sometimes we can be helpful, but we just want to get a sense of how you're remediating, the impact to investors, the immediate impact to investors, the risk, and just trying to get that level of communication. Sometimes cyber events happen when we have an exam open, so that's fortuitous. So we're already in the shop, we're already talking. Oftentimes they don't. I don't think it's typical we would open an exam based upon an event. Now, if it's something incredibly significant, a systemic player, maybe, just because that has an ability for us to get records and different tools that we can use to communicate than just a phone call. But it typically starts with a phone call. We have a group of ex-CIOs, cyber experts in our technology and controls program, which is sort of the gold standard for cyber in the commission that the biggest market players have to comply with, which already has a reporting obligation. So this team is used to that type of incident response, where they're getting immediate notification of an event. They open a bridge, they start talking, they start understanding what the firm is going to do. Now that doesn't happen for IAs, BDs, and sort of the vast majority of registrants, but we have that type of skill set that can interface with your chief technology officers, and it's just going to depend on the event, right? Oftentimes you're calling the FBI. If it's a ransomware event, we'll want to know what's happening in that result, but we're not there to get in the way. We're really there to learn what's going on, to make sure investors are sort of, the immediate reaction is make sure our investors are being served, whether they access to their funds, whether the funds are being shifted offshore, or what the risks are. So that's kind of how we approach cyber. And again, it varies. I mean, there are many cyber events we learn of that we don't do any. We say, okay, let us know what you're going to do. Get back to us, and whenever you remediate.
I think that's helpful to hear that perspective. Dan, let's stay with you and talk about private funds. Another, two sort of significant rule proposals out on that, and they follow risk alerts.
Some of it,
yeah. And so can you talk a little bit about how exams thinks about private funds and how your observations may have sort of been the same over the last couple of years, whether there have been changes in what you're seeing?
Yeah, we're very active in the private fund space, and I think we've been trying to get more information out. As you mentioned, we've had 2 risk alerts in the last year and a half or so on private funds specifically, and that is just a culmination of all the work we've been doing in the background. That I'm sure if you're a private fund advisor and or a manager of a private fund, you've been subject to an exam, we've been present in this space. But I think we're now at, I wish I knew the stat off the top of my head, 40% of advisors manage 1 or more private funds, and now there's a spectrum of that, right? It's the small friends and family versus this is our primary business. We get it. But you're close to half of our registrant population in the IA space. So we are there, and we're there in a real way. And it's not, we have a specialized unit, the private funds unit, which is our only specialized unit like that. But there are also private fund exams done by every sort of IAIC examiner in the region. So it's not just the unit. So we do a lot of private fund exams. And the risk alerts was really, trying to get out, again, proactively, the areas that we continually or repeatedly find issues when we're doing private fund exams. Fees and expenses. I mean, it's just, the vehicles have inherent control, the conflict that there are, on, I'm not going to say every exam because I'm sure that's not true. But on the vast majority of exams, we're going to look at fees and expenses. And we typically find issues. I mean, the exam teams are so good at this. I don't know how they do it. I mean, I'm just a lawyer. But they can ferret out, what you might view as de minimis, but we still view as important. Hundreds of thousands of dollars, millions of dollars, oftentimes remediation back to the funds before our enforcement colleagues. We view that as a win because investors are getting their money back a lot quicker. I mean, so that's the space. Fees and conflicts, just follow the risk alerts. New areas, I mean, the private fund industry is very creative. So we react to what we see. We've talked about stapled secondaries in our risk alerts. That's a relatively new area. But a lot of it is follow the money, follow the conflicts. And depending upon what your business is, MNPI we talked about. But just, as I said, in the last year and a half, we've been very transparent. That's what we're looking at. That's what we're going to get to. It's fertile ground. It continues to be fertile ground for the exam program.
Thanks, Dan. So let's switch gears again to you, Adam, and talk ESG. So you mentioned we mentioned the ESG task force. Can you talk a little bit about its work? And then there's a recent case that I view as an ESG case, the Wahed case. It's also a case that has a digital advisor involved. So I'd really like to get your thoughts on whether the fact that it was a digital advisor played any role in it, and then the ESG sort of thoughts.
Sure, thanks. So just very briefly on the ESG task force in enforcement, Dabney and I are both members, as I said at the top, and it draws from about 20 people, give or take, across the Division of Enforcement, and it has 2 core work streams. Most relevant to this group is an IAIC work stream where we're looking at advisors who purport to follow ESG strategies, and I don't think it should be a surprise that one of the things we're most interested in is whether their investment process squares with the representations that they make in marketing and other materials. The second thing that is interesting and that came up in the Wahed case is whether policies and procedures are consistent with disclosures. And so turning to Wahed specifically, Wahed was a robo-advisor case. It was a startup at the time of the conduct, and there are sort of 3 courses of conduct that happened in Wahed. One was a representation that Wahed was going to invest client assets into proprietary funds, or into funds that Wahed also advised. But Wahed didn't invest those assets into the funds because the funds didn't exist at the time of the representation. The second was when those funds did come into existence, Wahed invested client assets, this is what our order finds, Wahed invested client assets into those funds without disclosing the related conflict. And then the third piece that's probably most interesting from an ESG perspective is that Wahed purported to have a Sharia compliant, as Wahed defined it, investment process, but the order found that Wahed didn't adopt or implement policies and procedures to ensure that the investment process was followed. And so I think there's a message there for ESG in that if you say you're going to follow a particular investment process, you need to have policies and procedures in place to make sure that process is followed. I don't think that should be a surprise either. We've brought cases that involve failure to adopt policies and procedures to follow investment processes for a lot of different investment processes, or particular risk controls. These are traditional tools applied to a strategy that's become increasingly popular. I think the same is true for the fact that Wahed was a robo-advisor case. This is our 5th robo-advisor case by my counting, and 3 of them have been since last June. I don't think that's a surprise. As Dan says, we follow where the money goes, and robo-advisors are projected to have something like $1 trillion in assets under management in the next couple of years. So I think it's quite likely that we'll continue to see cases in that space as assets flow that way, and in particular, if we have scenarios like startups where maybe they don't have as robust of a compliance infrastructure as they try to get into the new area.
Thank you, Adam. Dan, so you probably won't be surprised to hear that limitations of liability and indemnity clauses in advisory agreements are fairly common, across the industry. And, we really seem to be watching an evolution here, starting with a footnote in the fiduciary interpretation to an enforcement case, a risk alert, and now, the private funds rule proposal. So can you just talk about the exam focus here, both in the context of retail agreements and institutional agreements?
I can try, but like many others, when we start talking about hedge clauses, I need to take a step back. In fact, I did that last night, and I went back and read the Heitman letter, which was the one that was withdrawn. And maybe not ironically might be the right word, but the source of that letter was actually an exam from our Chicago office, Midwest regional office at the time, and the law firm was like, the examiners got it wrong. What does IM think? So that's kind of made me feel kind of a little good that the examiners looks like they might have had it right. They were just a little ahead of their game, because it has shifted a little bit through the fiduciary interpretation. It may shift a lot bit with the rule proposal, but that's not what we're here to talk about. What exams is looking at? So I think if you look at the interpretation in the retail space, if you're a retail advisor, retail clients, I would be very careful with a hedge clause. I mean, I don't know if I were a practitioner, a lawyer, what I would be comfortable drafting that I would say, well, you're good. The SEC isn't going to have a problem in the retail space. The position was pretty strident, and that's the commission's view. It's a commission interpretation, so we're just following the commission interpretation. And we talk to IM when we see hedge clauses. We'll get their views, because we want to make sure we're on the right side of their views of the law as being much more integrally involved with those discussions with the commission. In the institutional space, it's much more difficult, or there's much more variables. And we did in our private funds risk alert, we talked about looking at hedge clauses, and because we do see some, even in the institutional space, that are head scratchers, where they're essentially sort of dissuading all fiduciary obligations. Now, that's a 206 problem and a 215 problem in the Advisors Act. Likely going to get a deficiency if you're looking like that. Now, the savings clauses, they're very helpful. So it becomes very facts and circumstances in the institutional space. And those are areas, again, that we are going to talk to IM. We're going to get their views before we issue a deficiency, unless it's something we've already seen. But I think if you're in the institutional space, I think you can, if you look at the guidance, even if you look at our risk alert, you have some ability perhaps to continue to use hedge clauses. And then there's the rule proposal, which we'll see what happens.
Okay, great, thank you. So we have very little time left. I want to make sure that I give you the second code word for continuing education. It is unique, as in our panelists have indeed been laser focused on providing unique insights.
I feel like this is an infomercial.
I know.
Laser.
I know. Adam, let me give you the last word. Talk to us about duty of care.
Sure. So this is a topic that's in the fiduciary interpretation that Dan was talking to just a moment ago. Commission interpretation that the fiduciary duty, as I think everybody in the room is well aware, includes both a duty of loyalty and a duty of care. And that duty of care shows up in commission orders and enforcement actions. It shows up in, for example, the share class space as a best execution violation. That's something that we think of as a duty of care violation. I think it's also something that you're seeing in our cash sweep cases. And sometimes that's not phrased as best execution. It's phrased as just a breach of a duty of care. And we will find situations where the order will recite that the advisor did little or nothing to evaluate other options, and we are bringing that claim under Section 206-2 in these cases. So it's something to think about to make sure that you have a good reason and have done the due diligence to understand why you're making a particular recommendation that you're making.
Thanks, Dabney. Do you want to add anything on that?
No, I think Adam did a great job covering it.
Okay, great. So everybody please join me in thanking Dan, Dabney, Adam